Hi everybody, the chat is currently active if you want to speak amongst yourselves. We'll be starting in 10 minutes. We'll be starting in 5 minutes. We'll be starting in 2 minutes. Judge Untelter, could you? There we go. Okay, we'll be starting just under a minute, so it's about a few seconds. Okay, it's 7:30. I think we are about ready to start. Judge Untelter, you ready?
I'm ready whenever you are.
Perfect. So I just need to write one last thing down. Okay. Perfect. Good evening, everybody, and welcome to what I'm sure will be a very interesting talk on Roe versus Wade. Before I introduce Judge David Unterhalter, a little bit of housekeeping first. At this point, we are also live streaming on YouTube for those who are not part of the medical field, so they can become more aware of this topic. For those on the YouTube stream, please be aware that there is a slight delay. And if you have any questions for Judge Unterhalter, please put in the chat, which is on the stream. I will take them down and I will feed them to Judge Unterhalter during the Q&A session. On the Zoom, for the duration of Judge Unterhalter's presentation, the chat will be disabled and will be reactivated for the Q&A. If you have any questions for Judge Unterhalter, please use the Q&A option, or if you have any technical queries, please use the Q&A as well, and I will get back and I'll respond as soon as I can. Now, on to the main event. And again, I would like to thank once again Judge David Unterhalter for agreeing to join us tonight, as well as I would like to thank the Wits Legal Clinic for helping to spread the word of tonight's talk. Now on to Judge David Unterhalter. If we were given 5 minutes, I doubt we'll be able to cover everything in his CV. But thanks to Judge Unterhalter, we know that he holds degrees from Trinity College, Cambridge, University of the Witwatersrand, and the University College, Oxford. And since 1990, Justice Unterhalter has practiced at the Johannesburg Bar up until 2017, and the silk was conferred upon him in 2002. He specialized in competition law and other areas of regulatory law, trade law, commercial, and constitutional law. In 2009, he was called to the bar in London and was a member of the Monckton Chambers. He served on a number of World Trade Organization panels and was appointed to the WTO appellate body and served as its chairman. As an advocate, he appeared in courts and tribunals in South Africa and the UK. He has done extensive international arbitration work. He is currently a professor of law at the University of Witwatersrand, well, was a professor, the director of the Mandela Institute, and is a professor of law in the Faculty of Law at the University of Cape Town. In 2018, he was appointed to the High Court as a judge. He has since held appointments on the Competition Appeal Court from June 2020, the Supreme Court of Appeal in 2020 to 2021, and is currently an acting judge of the Constitutional Court, so February, March 2022, and May to about, and currently now. With all of that, I now turn over to Judge David Unterhalter on the topic of Roe versus Wade. Over to you.
Thank you, Alexander, and thank you for the invitation to engage you. A small correction, I finished my acting appointment in the Constitutional Court at the end of July. What I want to do in my opening remarks are three things, perhaps four. The first is to introduce some of the moral, ethical, and political issues that arise around debates concerning abortion. The second thing I would want to address concerns the decision in the United States of Roe versus Wade, which established the proposition that there is a constitutional right to an abortion, and the recent overturning of that decision, which is something of an equivalent to a legal earthquake, at least in the United States, in the decision of Dobbs and Mississippi, and the implications of those rulings and how the US Supreme Court came to overturn its own decisions as it did. I want to explore some of the implications of this for what is happening in the United States and what is likely to happen as a result of Roe versus Wade being overturned. And then I wanted to turn to the South African position and sketch the law briefly in South Africa and perhaps indicate some of the constitutional questions that may yet arise in this country and require determination. So that's what I have in mind in the next 30 minutes or so of my opening remarks. Let me begin then with the ethical questions that arise around abortion. There are few topics that cause as much debate as the question as to whether a woman should enjoy the right to abortion, and if she does enjoy that right, under what conditions and within what time periods. Sometimes this debate is presented in very, very stark terms. And that debate is essentially one which says, on the one hand, there are rights that the fetus has to life, and a fetus is equated to a person. And since we value the right to life of all persons, there is no reason why the fetus should similarly not enjoy those rights. And so there is a grouping often of beliefs, sometimes firmly held religious beliefs, that says that an abortion is simply a deeply wrong form of intrusion and infringement of the right to life of persons who are as yet unborn, but nevertheless enjoy those rights as persons. There is, on the other side of this debate, when it is starkly put, the proposition that says that women have rights over their bodily integrity and the fundamental choices as to how they will conduct themselves in the world and how they have rights over their body and the choices that entails. And that fundamentally the question of whether there is a right to abortion is a right about personal autonomy, and that women should not be denied this fundamental right to make these kinds of fundamental choices about their lives and how their bodies will be used. And that is the counterpoint to the right to life debate, or the right to life position. These two sets of rights, of course, have many, many entailments, and there are many, many nuances to the argument. So, for example, there are those who would, by and large, favor the view that the right to life should significantly constrain the right to abortion, but that there are important exceptions, such as circumstances where the woman's own life is at risk as a result of the pregnancy, or where the pregnancy has occurred as a result of rape or incest or other circumstances of that kind. And that can then tilt the moral balance against an absolutist stance, which would say that there can never be a right to abortion because it is simply equated with murder. On the other side of the debate, plainly, even those who are strong adherents to the position of the autonomy account as to why women must have the right to choose, would themselves recognize that there are points at which once a woman is carrying a viable child, there are interests that affect the unborn child that count and count significantly, and that there is not at that stage an untrammeled right to an abortion. And so there are countervailing interests, and some would say even countervailing rights, once the child is at least viable in the womb. There is also another group of those who would say of this debate that wherever you might come down on the debate as to the right to life and the questions around autonomy, that effectively this is simply a question of liberty, and that whatever your views as a moral matter might be, this is simply a question that touches matters of such intimate personhood that on grounds of pure liberty, the state should simply not be involved in making these kinds of decisions, whatever the ethically correct position may be. So you could take the stance that says, well, it's simply not an area in which the state can have any legitimate interest in seeking to regulate what people do. And even if people do things that may be ethically wrong, the state has got no interest in regulating this aspect of deeply personal ethical interest. So that's part of a very long debate. It has been going on for millennia. It has deep religious, moral, and ethical connections, and people feel extremely strongly about this. I use that as a backdrop, however, to sketch one other feature of these debates, which is that they are not only debated ethically and religiously, but of course, and certainly in the United States, they've come to feature very prominently in the politics of that country. And they feature not only because people have strongly held views on these matters, but because they have come to feature in what is increasingly a form of tribal division in American politics between liberals, by and large, on the one hand, who are Democrats, and those who now people the Republican Party, where this issue of abortion can often be an important lodestar for conservative thinking and for allegiance to the Republican Party in increasingly divided camps where little common ground is to be found in the middle. And the question, and there are interesting questions as to how abortion came to play the political role that it now does. It wasn't always so, and why it is a touchstone for such extraordinary political division in the United States. So there are ethical questions, there are religious questions, there are deeply held views, there are important political implications of this debate, certainly in America, but also in other countries. And then, of course, there is the terrain of the law. Now, I'm going to spend a bit of time, obviously, on this part of the discussion because it raises numbers of extremely interesting questions, and questions that are not just interesting, I hope, for lawyers, but for those who have an interest in how the law articulates interests in and around the abortion debate. So let me take you to the United States and to the famous decision of the United States Supreme Court in 1973 of Roe versus Wade. The person concerned in that case was a woman who had fallen pregnant and she had 2 children already. This was to be her 3rd child. She did not want to take this pregnancy to term and have a 3rd child. She was not well circumstanced to have this addition to her family, and she wished to have an abortion. At the time, the Texas laws did not permit of abortion, and the only exceptions were to save the mother or in circumstances of incest or rape. And she brought a case to challenge these prohibitions in Texas law, which prevented her from having an abortion. The matter eventually found its way up to the United States Supreme Court. And as I'm sure many of you will know, that court then held that there was indeed a constitutional right that a woman had to an abortion, not an untrammeled right, but a right that had its source in the United States Constitution. So let me begin with what was the basis of that decision. It was found to arise from the 14th Amendment, which is one of the provisions in the United States Constitution, which says that no state may deprive a person of life, liberty, or property without due process. Now, one of the questions that arises is, well, how did the court derive the right to an abortion from that provision? And effectively, what the court said is that although there is no express right to privacy that is captured by the 14th Amendment, there was what the court described as a penumbra. In other words, that there was a reach that the 14th Amendment had that would permit of the recognition of a right to privacy, and part of the right to privacy was the right of a woman to choose how whether a pregnancy that she had would go to term, and that was the right to abortion. So that was the grounds upon which the case was decided. There are two things to observe about that ruling. The first is that it was not the first occasion on which the court had found that certain aspects of personhood that are deeply personal and specific to the way in which people choose to lead their lives did ground constitutional rights. So in a number of important decisions that went to, for example, the right to use contraceptives, it was said that this was a personal choice that was grounded in a right to privacy and which the Constitution protected. The second feature of the decision in Roe versus Wade, which is important, is that the court indicated plainly that although there was a right to privacy and hence a constitutional right to abortion, it was not a right that was unconstrained. There were points at which the state had an interest in regulating the ways in which a pregnancy could proceed, and it created a scheme under which various different burdens attached to what right could be exercised to an abortion at different stages in a woman's pregnancy. And the further progressed the pregnancy was, the more difficult it was plainly for a woman to exercise a right to have an abortion. The first trimester, there was essential freedom to do so. And as the trimesters went along, so there were ever greater state interests in regulating the rights to abortion, and a woman had progressively less autonomy in exercising that right to choose. So that was the scheme that existed under Roe versus Wade. And at the time that the decision was given, it was a controversial decision, certainly, but for a fairly long period of time, Roe versus Wade was not the subject of significant legal contestation. But there began to build, pretty much from the time that Roe was decided, a very, very substantial grouping of people, some of them of religious dispositions that considered Roe to be an affront to their religious beliefs, others who had ethical beliefs that they thought were affronted by Roe. But it came in the United States, and I'll come back to this point if you're interested, to assume an ever greater political significance as particularly conservative Americans and those with political affiliations on the right of the political spectrum came to align themselves with those who had strong beliefs about abortion and considered that Roe versus Wade was an affront and that it should be overturned. And that was one stream of response to Roe versus Wade. But a great deal of time went by because the decision, as I've indicated, was decided in 1973. And for decades and decades and decades, women have enjoyed the right to an abortion grounded in the constitutional ruling in Roe versus Wade. And an important point was that at no point after Roe versus Wade was decided did the federal legislature, Congress in the United States, pass legislation which made this constitutional court ruling part of federal law. So those states, many of which were governed by legislatures that did not agree with the ruling in Roe versus Wade, were nevertheless constrained in that their laws would be struck down as unconstitutional if they sought to limit the rights to abortion beyond or in a more restrictive way than Roe versus Wade permitted. Not only was Roe versus Wade a decision that held fast for decades and decades and decades, but a matter went up to the United States Supreme Court called Planned Parenthood versus Casey in the 1990s, where the United States Supreme Court again affirmed the constitutional right to an abortion. And the only thing that it changed was that it changed the periods over which different regimes applied to abortion to a different test, which was that it considered fetal viability to be the point at which the right to an abortion became significantly attenuated. And then the question was what very limited circumstances would then permit of an abortion. But again, the essential structure was confirmed, which is that women do have a right to an abortion. It is founded upon the right to privacy, and that the state's interests in the progress of a pregnancy changed as the pregnancy progressed, but more particularly when the fetus was viable, then the state's interests triggered, and there were very restricted circumstances in which an abortion could take place. So that was the state of the law in the United States up until the time that a case went up earlier this year to the United States Supreme Court and was argued, and that is the case of Dobbs and Jackson. This case is a case that challenged a Mississippi law that sought to restrict the right to an abortion up to a period of 15 weeks. So it wasn't an abolition of the right to abortion, but it was a constraint upon the fetal viability test, which was the basis upon which Casey had been decided. So it was a restriction on the right of abortion that was more stringent than the regime that had arisen from Roe and followed with some modification in Casey. Now, before telling you a little bit about how that case was decided, it is important to remark that the political controversies over abortion in the United States grew over the years in ways that I have already in part described. But one aspect of the politicization of abortion was a very, very deliberate political campaign forged largely through the Republican Party, and in particular through an organization called the Federalist Society, which sought to ensure that federal judges were appointed who were more likely to be sympathetic to the overturning of Roe and the recognition of the right of abortion in the US Constitution. And the influence of the Federalist Society upon federal court appointments has been very, very considerable. Hundreds of judges have been appointed essentially on recommendations made by the Federalist Society. But much of this came to a head under the Trump presidency, where for various reasons, which I won't dwell on now, President Trump had an opportunity to appoint 3 justices to the United States Supreme Court. And in so doing, fundamentally altered the composition of the US Supreme Court, and it was largely thought would alter the composition of that court in such a way as to make a challenge to Roe versus Wade a very likely challenge that might overturn it. And so it turned out to be. The way the court divided on the issue that came before it, which was whether this Mississippi statute was unconstitutional or not, was that the majority of the court, as to 6 of the 9 justices, held that in fact the Mississippi law was constitutionally permissible, and 5 of the 6 who came to that conclusion held that the that Roe versus Wade felt to be overturned. So let me tell you a little bit about how Judge Alito came to make that decision, because it's of interest certainly to lawyers, but I suspect it will be of interest to those outside of the narrow legal debate. Judge Alito and many members now of the United States Supreme Court are judges who approach the Constitution from a perspective that is called an originalist perspective. That says, we look at the text of the Constitution and we ask ourselves, what did that text mean at the time that it came to form part of the United States Constitution? So when we see that there is a 14th Amendment and we read the words there that there is that there's no state may deprive a person of life, liberty, or property without due process of law, we must take that text, interpret its textual meaning, and understand it in the light of what that text meant to those framers who placed it in the Constitution in the first place. That is, as I've said, an originalist position as to how to interpret the Constitution. Well, Judge Alito said that, firstly, there is no express right to abortion that can be found in the US Constitution. That Roe versus Wade was predicated on a right to privacy is itself something which he said he could not find in the Constitution. There isn't a right to privacy in any text that you can read in the Constitution. And as to the 14th Amendment, which is the foundation for Roe, he said, well, to the extent that there are liberties that are referenced in that provision, those can only be liberties of a kind that were recognized at the time that the 14th Amendment was passed in the 19th century, which in fact is in 1869. So Judge Alito proceeded to engage upon a lengthy account of what liberties were available in 1869. And he traversed English common law and the various statutes in the United States at the time, and found that there was a widespread recognition that abortion was illegal. It did not form part of any right that anybody had. And so he reached the conclusion, based on this traversing of the history of abortion and how it was understood in the law at the time, that it was prohibited, that it was illegal, that there were mostly very few exceptions, if any, that would permit of abortion. And consequently, he said, well, there was no liberty to exercise in respect of a right to abortion. There was no right to abortion that was intended in the 14th Amendment. And consequently, he concluded that since there is no right in the Constitution to an abortion, this is a matter that must be left to the states, the individual states, and they can regulate abortion as they see fit. That's a legislative matter. It's not a matter of constitutional right. So held the majority of the court. The Chief Justice Roberts, although he did not find that the Mississippi law offended against the Constitution, was much taken up by a different problem. And it's a problem that lawyers face all the time and is very much part of the way law works, which is when a court decides a case, particularly a case of the kind of importance that Roe represents, the doctrine of precedent, which is that courts adhere to their past decisions, both hierarchically, when the highest court decides a matter, lower courts are bound by that decision. But equally, even the highest court will have very careful regard to the precedents, because if courts kept changing their views as to what the law was, then the law and the rule of law would become significantly compromised. Now, Chief Justice Roberts, who is described, I think correctly, as an institutionalist, was very concerned about precedent and the fact that Roe versus Wade, even as slightly reinterpreted in Casey, had stood for nearly 70 years and gave rise to a rooted set of expectations that women had to be able to enjoy the right to an abortion. And so he was not willing to overturn Roe nor overturn Casey, but found that the 15 or 16-week period within which a woman was permitted under the Mississippi law to have an abortion was a sufficient basis and did not impose an undue burden upon women. And so he found that under the test in Casey, the law still passed constitutional muster. Plainly, the minority of the court, the three liberal justices on the court, not only said that precedent couldn't be overturned in the manner that it was, but said that there were plainly grounds in the Constitution to recognize the right to an abortion, and so they dissented. So you have a court that is split between conservatives on the one hand, who here upheld the notion that the states, abortion is a matter that must simply be sent back to the states for them to regulate it as they will, and those in the minority who continued to adhere to the position of Roe and said how important it was that precedent should be applied. Now, there are a number of things about the implications of the decision in Dobbs, and let me come to those because they're important and they are likely to occupy much terrain, both legally and politically in the United States. And often what happens in those kinds of debates has implications for other jurisdictions such as our own. But let me just briefly sketch what the implications are. The first is that although Alito's decision said, although we find there's no right to an abortion, and that we cannot source that right in a right to privacy and a right under the 14th Amendment, Judge Alito said, well, that doesn't affect, this is simply a case about abortion. It doesn't affect other rulings that the court has made, which are sourced in a similar conception of rights. For example, the famous case of Griswold versus Connecticut, which said that married couples and others who make very, very personal decisions around the use of contraception are entitled to do so as an incident of their privacy and the kinds of rights that attach to the family and deeply personal rights that people make as to how they wish to lead their lives. Well, said Judge Alito, nothing about this ruling should be implied to overrule rights to contraception. And similarly, the rights to have same-sex partnerships, which is also rooted in the United States, in US law, to rights of privacy and the way you choose to lead your life and form certain partnerships, which such as same-sex unions. One judge, well, let me leave it there. What critics have said of this decision is twofold. The first is that originalism is a peculiarly restrictive concept for the interpretation of the Constitution. Some of the most important decisions that have been made in modern US constitutional law, such as Brown versus the Board of Education, which found that separate and discriminatory provision of education in the United States offended against the Constitution, which was itself an overturning of earlier decisions such as Plessy versus Ferguson, and was universally welcomed, obviously, as a progressive realization of constitutional rights. If you apply an originalism to the US Constitution, well, you might readily have to concede that the US Constitution was conceived in circumstances where there were deeply held social norms and indeed laws that permitted of racial discrimination and indeed ultimately permitted of slavery. So how you can interpret the Constitution in this manner would set the clock back in ways that would constitute radical potential revisions of decisions that are universally considered not only to be correct and ethically required, but to be the modern and progressive realization of the United States Constitution. So the first is to challenge the notion of originalism and to say that if this is how the Constitution is to be understood, well, it has very grave implications for the way we interpret constitutionalism in a modern era. The second critique, which is important, is to say that actually, even if you apply an originalist criterion, the way in which Judge Alito read the historical record was itself highly partial and actually gave expression to values and views that in fact don't reflect the deeply held convictions of the country, even at the time that the 14th Amendment was passed, because of course the laws that were there reflected many of the deep forms of discrimination that then existed in the United States society, including limited franchise, women didn't have the vote, and so on. So how the laws that then prevailed are a proper reflection of the deeply held convictions of the society is a very, very partial reading of what the historical record should properly reflect. So there are lawyers' debates, but there are also very significant implications. Let me give you some others just as a brief overview. The first is that many states in the United States had passed what are called trigger laws, that in anticipation of overturning Roe versus Wade, laws would immediately come into force. And that's exactly what has happened in many, many states. More or less, just less, I think, than half the states in the United States, almost overnight, had laws that were now highly restrictive of the right to abortion. So the country is now a patchwork of jurisdictions, some of which have adhere to very liberal provisions for the right to abortions, and others which either have or will have shortly highly restrictive laws, including laws where, for example, there's much debate as to whether even exceptions that historically were fairly well recognized in respect of rape and incest, even those would be considered would be taken off the statute books so as to have a pretty much blanket ban on abortion. So that's the first thing. The country is split and the laws differ greatly, and obviously that has major implications for women who would exercise the right to have an abortion. There are also very complicated questions that arise because a great many abortions today are effected by way of pills that can be procured through the post. And whether certain states that oppose abortion or that their legislatures oppose abortion are going to seek to try to prevent people either traveling to other states to get abortions or seeking to procure pills that would permit them to have abortions is another entire minefield. The third aspect is that many states where there are legislatures that favor the right to life, and sometimes in very entrenched and fundamental ways, are seeking to have legislation passed which says that a fetus is a person. And once that comes into being, all sorts of consequences follow, including the fact that somebody who attempts to have an abortion could be liable for murder, and other slightly more unusual consequences that would logically follow, such as the fact that a fetus might be entitled to child support, entitled to tax exemptions, and a whole variety of consequences that flow from the recognition of a fetus as a person, a matter I will come back to. The other feature of this in the United States is that even though there are very significant divisions in that country politically, as between conservatives and liberals, Democrats and Republicans, almost all polls show that something of the order of about 70% of America does think that women should have a right to abortion, at least in some respects. And that had an interesting resonance recently, where the state of Kansas, which is a very conservative state, was not willing to change its constitution that did allow the right to abortion. A majority of voters in that state said they were not willing to change the constitution. It's a state constitution, which did recognize the right to abortion. There are also very important things that are likely to happen at a federal level, where if, for example, as some people think in the midterm elections that are coming up, Congress in the United States falls to the Republicans, well, there are many efforts afoot to try to, at a federal level, outlaw abortion, which would have very significant consequences in the country. So that is a sort of overview of what has happened in the United States and what some of the implications in that country are as a result of the overturning of Roe versus Wade. Let me then lastly, and very briefly, but we can take this up further in questions if you will, just come to the position in South Africa. The matter in this country is regulated under a statute, the Choice on Termination of Pregnancy Act, which was a piece of legislation which came into being after our democratic constitution was put in place and in light of some of the rights that are recognized in the constitution. And I should say that our constitution is very differently structured from the United States, and I'll be interested if you wish to take up some of those questions around what our constitution provides for. But effectively, the legislation that was passed really divides a pregnancy up into periods, and in effect, up to 12 weeks, a woman has a pretty much unfettered right to choose whether to have an abortion. Within the period of 13 to 20 weeks, there must be some risk to the physical or mental well-being of the woman. After 20 weeks, there are highly restrictive categories that would still permit of an abortion, and they have to deal with essentially where there is a threat to the life of the woman, or there is a significant risk to the child, who may suffer some very significant handicap if the pregnancy went to term. So that's the overall scheme in South Africa. There has been some litigation, and in one important case, which did go to court, though it never ended up in the Constitutional Court, which was the Christian Lawyers Association of South Africa. The question arose in that case from the applicants as to whether the legislation was not unconstitutional because a fetus has a right to life, and the Constitution recognizes the right to life as one of the fundamental rights that exist in the Bill of Rights. The case ultimately then turned on a fundamental question, which is whether a fetus is a person and hence is recognized as the bearer of the rights in the Constitution. The court there held that it was not so, and so did not have a right to life, and consequently, on that ground, the legislation could not be overturned. There are important provisions in our Constitution, unlike the United States Constitution, which particularly in section 12 of the Constitution give express recognition of everyone's right to bodily and psychological integrity, which includes decisions concerning reproduction. So there is a very, very clear recognition in our Constitution of the very right that was recognized in Roe versus Wade, but here in express terms in the Constitution. What is yet to be determined is whether the Constitutional Court would take a different view as to whether a fetus is a bearer of rights and is a person for the purposes of the Constitution. And that would then give rise to a very complicated debate as to how, if the fetus is a bearer of the rights to life, how that would be weighed up in relation to the rights under Section 12 of a woman to bodily integrity and reproductive choice. But that case hasn't come, and on the rulings that currently apply, a fetus has not been held to have a right to life, though there is recognition that there are interests that a fetus has, and there may be certain ways in which the fetus could nevertheless have constitutional standing for certain purposes, but that jurisprudence has yet to be developed in our law. So let me leave it there. I've spoken for longer than I intended, but I hope to give you a bit of a sense of the terrain of this debate. And I'd be happy to now take your questions and discuss points that arise that you would like to raise.
Thank you, David. That was beyond interesting. I'm not seeing anything in the Q&A at the moment, and I would just like to remind people that the chat has now been reactivated. But if you have any technical queries, please put them into the chat. If you have any questions for Judge Unterhalter, please put them into the Q&A. To start us off, just a question from my side, Judge Unterhalter. You mentioned how that with the current ruling by Justice Alito, that it's to be handed down towards the state level. I remember reading that on the for it to be codified on the national level, 4 states will need to codify it in their domestic legislation. What would be the process in the South African context? How does something go from become legislation, or codified legislation in South Africa?
Well, obviously, our system is rather different from the United States, where, I mean, the United States Constitution it's a federal state. And so the states have very, very significant competences to determine matters, including matters such as how to regulate abortion. The way in which the problem arises, though, in the United States is that legislation could be passed both at a federal level by Congress, but similar, and so could it be passed and has been passed by state legislatures. The reason that the debate has been pursued in the way it has in the United States is that, of course, if there is a constitutional right to an abortion, then a state legislature may pass a law, but it would be struck down as unconstitutional to the extent that it limited the right to abortion. And that's precisely what Roe did. So for the nearly 70 years that Roe prevailed in the United States, legislatures could not bring into force legislation that sought to restrict rights to abortion on the part of women in ways that were more restrictive than those permitted by Roe. And that's precisely what happened for years and years. So sometimes legislatures would seek to do so, such as the Mississippi statute, but the law couldn't be put into force because it violated the constitutional rights as they were understood in Roe versus Wade. Now that those rights by a majority in Dobbs have been said not to exist, the constitutional constraint provided by these decisions is taken away, and now the matter is left to the legislature. And in our law, you would have a slightly different structure, which is that it would be Parliament that has passed laws concerning abortion, and if there's a constitutional challenge to that law, well, then that would go to court, as it did in the Christian lawyers case, and the court would test that law against the rights in the Constitution. And if it found that it violated the rights, then it would, to the extent of the violation, it would strike down the law.
Good. Thank you. We got some questions coming through in the Q&A now. Just a reminder, if you're putting your hand up as an attendee, if you have a question, please put it in the Q&A. If you have a technical query, please put it in the chat. So our first question here is that how likely would it be that with the Roe versus Wade being overturned, the US could start overturning other laws like gay marriage and etc. and access to contraceptions?
Yeah, well, I mean, this is one of the burning questions that flows from the Dobbs decision, which is effectively this. Although Judge Alito was very careful to try and say that his decision and those that joined him was a decision that was effectively only about abortion, and that all that was being decided was that there's no constitutional right to abortion, and consequently these matters can be regulated by state legislatures. The matter should be returned, as it were, to the state legislatures. The legal logic that underpinned that position, as I already briefly alluded to, has obvious implications for rights that have been recognized and are very, very important rights, which rest upon the same legal foundation. So if you take, for example, Griswold versus Connecticut, and rights to contraception, rights to same-sex unions, all of these are deeply personal decisions that people may take, and they are rooted in a conception of the right to privacy, which is exactly the same construct that gave rise in Roe to the right to abortion. Well, the question is now, why are they distinct? Why would they somehow now not be vulnerable? And this is where that originalist argument has particular complications, because if you ask yourself whether in 1869 the same-sex unions were lawful, the answer is that in the majority of states in the United States and at common law, sexual relationships between same-sex partners was unlawful. So the same kind of trawl through what in the 19th century was considered to be illegal would probably yield the same kind of result. And so many people say, well, there's not an obvious basis upon which, some of these other areas would not potentially now be subject to challenge. So yeah, there are some very significant questions that now arise. I mean, one of the justices, Justice Thomas, in a concurring opinion in Dobbs, basically said, well, yes, and these other matters do need to be looked at. So he's raised the very concern that people on the liberal side of this debate worry about considerably.
Thank you. I just want to follow up on that, because you mentioned how some laws or rights in the past would not be considered to be challenged, as it makes sense. So it would be fair to say that laws are more understood in context. And on that, should there probably be a statute of limitations when it comes to referring to these rulings or rights as precedent, considering the modern age and how we look to progress?
Yeah. Well, Alexander, I think the issue there is a twofold one, which is that this case is full of interesting paradoxes, but I mean, one of them is that certainly the Chief Justice and the three liberal justices on the Supreme Court were saying we should be adhering to precedent, because the ruling in Roe versus Wade has given rise to deeply important rights that people now depend upon in the way in which they construct their lives. And so for a court now to go and overrule all of this is deeply problematic. Now, what Judge Alito said about this is, well, if a ruling is wrong, if a decision is wrong, then the court must square up to the fact that it's got to put the law on a proper footing, which might sound sort of reasonable. But when people have come to rely on a precedent for a very, very long period of time, one has to think very carefully about changing a precedent. But I think your question also touches on this issue around interpreting constitutions, which is the essential framework within which a constitutional order operates, and adopting this originalist position, which says, well, the right way of interpreting a constitution is simply to try and understand what a particular text meant in the context of and at the time that it was formulated and placed in the Constitution. That is a very strongly held view by conservative members of the court, and it is thought to have its origins, in a sense, in the idea that the court should not be seen to be interventionist and activist, and the way to keep it within the bounds of its proper power is to have this very kind of constrained reading of the Constitution. But it can give rise, and I think in this instance has given rise, to some pretty strange views, which is to say, well, if your test is whether a particular right happens to form part of the deeply held convictions of a society, it's hard to say that those convictions are reflected in what laws were passed in 1869, when those laws were effectively the result of what propertied white men thought about the law at the time.
Mm-hmm. Agree. So moving on, we got a few questions relating to this. Does a South African doctor have the right to refuse to do an abortion? I think mainly based on grounds of personal belief.
I mean, it's an interesting question, and I'm not aware that a South African court has yet determined that question. I mean, it does implicate issues, or at some level, it implicates questions of belief. At another level, it can implicate issues of labor law. And one suspects that in most instances, it is not actually going to become of practical importance, because as long as a woman is able to procure the abortion that she has a right to under the legislation, it's not clear that she can insist that a particular doctor must perform that abortion, even if that doctor happens to think ethically, privately, that that it's wrong to do so. So, I mean, I'm inclined to think that unless there was some very unusual case in which a doctor, it was necessary that the doctor had to do so, and the question of a conflict of rights arose, in most circumstances, a doctor would be able to say, well, this is deeply contrary to my beliefs, and it's not clear that the law as it presently stands, the legislation, can require a doctor to act. It simply gives a woman a right to certain things. It doesn't say that that obligation must be exacted from a particular doctor. But I can see that there may be more complicated cases where this set of different rights is going to have to be determined one against the other.
Mm. Thank you. Our next question, and this is actually going to be a complicated one. Well, in South Africa, at what point does the Constitution identify the fetus as being a person?
Well, that was the case of Christian lawyers, where the court essentially said that the fetus is not a person. Mm-hmm. So where in the Constitution you will read that, I mean, one of the most important rights that our Constitution naturally recognizes is everyone has the right to life. So the question is, well, who is everyone? Now, law as it presently stands is that the fetus is not a person, doesn't fall into the class of everyone, and that would be so up to the point that of birth, where the baby then becomes a person upon birth. Now that notion might be subject to consideration, I suppose, under the kind of standard that was made applicable in the United States of viability. In other words, could it be argued that at least a viable fetus had a right to life? I don't think that proposition has been tested. And on the law as it currently stands, the answer is not that a fetus is a person, but that doesn't necessarily mean that the state does not have an interest and could not regulate, as it does, the circumstances in which it can choose to intervene in the interests of a fetus, even if the fetus doesn't have a right as a person to assert rights under the Bill of Rights.
Thank you. I think these next two questions are pretty much the same, and they actually are a follow-up to the one we just previously answered. So what is asked was, how was the 13 and 20 weeks decided in South African law? Was there a medical decision behind it, or was it an arbitrary legal definition? And the second part of that question, although I think you may have answered, could these timeframes be constitutionally challenged?
Yeah. Well, let me come to both of these. I don't have a detailed knowledge of the of what served before Parliament in the there was, I think, a law commission, and I think evidence was taken and it examined what the basis of the time periods was. I mean, I think that the broad point is this, that a view was taken of the Constitution that says it does recognize the rights of women to bodily integrity and the rights of autonomy over their reproductive life. That is a right. But there are countervailing rights and interests that become availing the further the pregnancy progresses. So I think, you know, the first 12 weeks is one where you are far from viability, and essentially the concept, the way of thinking that prevails on these things is that the closer the fetus comes to viability and to some conception of potential personhood, the more there are interests in its protection, even if it isn't a person, and the more a woman's right to abort must become attenuated. The less the fetus is a potential person and is still far away from viability, the more one can legitimately, at least on this conception, think of it as, you know, a collection of cells that should not stand in the way of the mother's exercise of her the woman, I should say's exercise of her right to reproductive freedom. And so I don't think there's a cast iron way of calibrating how to weigh in the scales these different interests and rights. But broadly speaking, the legislation seeks to work along that spectrum, which I think is broadly reflective of these principles that I've been dealing with. As to whether there could be a constitutional challenge, I think the way in which that would have to work would be to say that, for example, if there were radical changes, as I mean, there are certainly changes as to when a fetus may be viable. I mean, I think in US law, it was, I think, around 21 or 22 weeks. But let's say there was a miraculous medical change that allowed for viability at a much earlier point. That could shift the basis in which the legislation is now framed from a constitutional perspective, because it could be said that that there are interests now at play that warrant a recalibration of the way in which we think about the interests of a child that is, I should say, a fetus that is a viable form of life. And that could give rise to a different kind of constitutional challenge.
Thank you. So it would basically come down to fetal development at the time. And as you said, as we progress, maybe fetal development will be shortened in time and may require a shift.
It could be. It could be. I suppose that there might be some arguments to say that, well, that, you know, a fetus could survive in certain circumstances. You know, that's just one way of thinking about this problem and where viability arises and what, you know, technological changes might do to change that norm. I mean, that's just one possible change that might give rise to different considerations in respect to the legislation.
No, it ultimately does come down to a trolley problem. Save the one life, save the other life. How do you balance it up?
Yeah, although on the law as it stands at the moment, the fetus isn't a person. So it's not a question of trading one life against another, one person's life against another. So the kind of trolley problem issue doesn't arise in a simple way. But certainly what is recognized is that the state has got interests in the development of the fetus beyond a certain point because of its potential life. And that's certainly reflected in the United States cases and I expect would be reflected in our law too.
Yeah. Like on the topic of principles, I got another question here asking if you could explain let's see if I say this right, the Nascaturus principle, and if that might have any relevance for fetal rights in abortion.
Well, the Nascaturus principle was an old principle of our common law, having origins in Roman Dutch law and the like, which did look precisely at this problem as to what are the rights, if any, that can be attributed to the unborn child, in other words, to the fetus. And there were many debates that took place as to what sort of interests might be reckoned with in respect of the child, of the unborn child. And, you know, some of the common laws to prohibitions against abortion were partly predicated on these views about the rights of the fetus. But the Nascaturus rule was examined in the Christian lawyer's case, but it was found not to give rise to the notion that a fetus is a person and hence is a bearer of the kinds of rights that are to be found in the Bill of Rights.
Okay, thank you. Okay, this is an interesting one. What is your take of the 3 Trump-nominated justices who, during their confirmation hearings, accepted that Roe v. Wade was established law and was precedent, and then apparently going back on that statement? What is your take on that?
Well, it's very interesting. The question is an interesting one, and I think there's a bit of prior history to this, which, if you're interested, I'll give you my take on. But there was a confirmation proceeding, as memory serves, I think in the 80s, maybe in the early 90s, but I think in the 80s, of quite a distinguished lawyer called Robert Bork, who was nominated to go to the Supreme Court. He was a distinguished lawyer, but a very conservative one. And when he came before the Senate for the confirmation hearings and was asked various questions about how he might rule on certain controversial cases, he told the Senate exactly what he would do. The result of this was that Bork was not confirmed, and the Bork issue or problem has resonated since that time, so that whether the nominee is a liberally minded justice or conservative justice, the basic rule of thumb is to give as little away as possible and to simply say rather anodyne things such as, well, this is a difficult case, so I will give it my, careful consideration. There are things to be said by way of important arguments on this point, and I promise to give it my full consideration is kind of the answer. There's just endless evasion on these matters from nominees. Now, when the three nominees were asked about Roe v. versus Wade, what they said, which is that it is a long-standing precedent, is not a commitment by them to say that they would never overrule it. Because, as indeed happened in Dobbs, the US Supreme Court has got the power to overrule its own precedent. Of course, there are good reasons to think that it should be very, very careful about doing so. And certainly many think that they should not have done so in respect of Roe. But to simply say it is a long-standing precedent is a correct proposition of law. It doesn't contain within it a commitment that you could never or would never overturn it. And so there are some who say that they went a bit further and said things like, well, it's a long-standing precedent and one would have to be very careful before overturning it. And so some say of Kavanaugh and others that they misrepresented their positions to the Senate. And some people even think that that might be a ground for impeachment, but I think that that's very far-fetched. But the truth is that what candidates say is to be very, very cautious, very careful, commit themselves to as little as possible, because of the Bork experience.
Thank you. This should be a simple one. In South Africa, do provinces have the right to decide their own position on termination of pregnancy?
No, this is a national competence.
Yeah, so we have a national government, whereas the US has a more federal government, which
just to be clear, the US is a federal system because states have very, very considerable powers to pass legislation. We don't have a federal system, but we do have a division of legislative responsibility between the national legislature, parliament, and the provinces. But on a matter like abortion, the competence really lies with the national legislature.
Thank you. Okay, this is a tricky question to answer. At what age may a child in South Africa make the decision to have an abortion without the knowledge and or consent of a parent?
Yeah, you'll forgive me, but I don't have the legislation in front of me, but there is a provision in the legislation that actually stipulates for that. I don't know why I have in my mind, but I'm subject to correction that I think a 15-year-old child, as memory serves, can choose to have an abortion without parental consent. But it's open to correction. I'd have to check the legislation, but there is a provision that deals with that proposition.
Thank you. We'll see if we can find some information on that. So, okay, I think we've answered those two. Okay, here's one. Could you please shed some light on the matter of an intern doctor at 2 military hospitals He was dismissed for advising a patient against having an abortion. They say they do believe the matter is still with the HPCSA.
Yes. I don't know of the cases, but I can readily understand that it may be, as one of the earlier questions raised, that a doctor who has very, very strong religious or ethical views against abortion may be able in certain circumstances to refuse to perform an abortion where the woman in question can get access to the abortion by doctors who are willing to do so. This is a slightly different class of case, though, because here there is advocacy to actually not have an abortion, which is not about a medical opinion. I mean, you go to a doctor to receive medical advice and to be able to enjoy your rights as a patient, which in this instance can include the right to have an abortion. I mean, on the face of it, I would have thought there is a case to answer by a doctor who uses the occasion of their medical practice to seek to persuade their patients about ethical positions on abortion. The doctor is entitled to have his or her views as to abortion, but in discharging professional duties, your duty is to the patient and the recognition of the patient's rights, which in this instance include a right to abortion. So I can understand that there's an issue about whether that is professionally permissible, whatever the doctor's ethical convictions might be. It's not clear that professional medical practice is the occasion in which to try to persuade people of your religious or ethical views.
Thank you.
But I don't know that the case has been concluded, and so I don't know what the outcome is, but I imagine that's the kind of issue that is being raised in that case.
Just back onto the previous question about the age of consent for a child under the age of 18. I've got here in the chat that the age is 12, actually. So they can.
I stand to be corrected. As I say, I don't have the legislation in front of me, but there is an age, and if that's what the legislation says, that's what it says.
Yeah, and I got here as well that according to the TOP Act, any woman, including a minor, may request and consent to a termination of pregnancy without requiring assent from parent, husband, or partner. So I think that's where our constitution understands.
Well, that makes, I mean, certainly one can't imagine that a husband or partner could ever override a woman's right to choose. The question of a child is something slightly different, but if the age is 12, then that's what the legislature has determined.
Thank you. We got a quote here. I will come back to this quote because it's still a long one. Just try to read it. So we got a question here. Do we have mechanisms in our constitution to prevent the hijacking of the apex court to support a political view or position?
Yeah, I mean, it's a very general question, but and suggests that, I don't know if it suggests, but maybe it's just being an abstract question as to whether the court is somehow hijacked or has been or could be. But the fact is that judges who are appointed to that court, as with all judges, are required to, they're required to act as judges, and that means that they are required to be independent, and their allegiance is to the Constitution and the values of the Constitution, and to act independently with loyalty to the Constitution. So if there were a judge who acted in some way simply to give effect to political preferences or to do the bidding of a political faction or party, then they would be violating their oath of office, and it would be potentially an impeachable matter. But I believe that the judiciary in this country is an independent institution, and judges are independent and act independently.
I would say I would have to agree with you on that. So we got a long question here. So from our attendee, in their view as a medical doctor and due to their role in practice, they do see legal cases such as rape, assault, and they believe that things are moving forward in society. So there is progress, and that evidence-based in conjunction with the society norms and beliefs, and they believe that we can not be led to believe that from 1800s, nothing did change and the evolution stopped then. So what they are asking is what exceptions are still valid in the USA now linked to abortion? The other question is linked to the care that any society must give to the mother and the child in terms of child support that now, in my experience, is not done as per law, but linked to the money access to pay a lawyer.
Yeah. So, I mean, the position in US law after the Dobbs case is a real patchwork, because as I was indicating, effectively, the effect of Dobbs is to allow state legislatures to determine the position. And that means that I mean, to put it very simply, you have blue and purple states by and large, which, give women the right to an abortion pretty much, essentially in line with Roe. And then you have states which have now passed or will be passing legislation which significantly restrict abortion, sometimes like Mississippi to 15 weeks. In other instances, there is legislation that either has been passed or is proposed that would pretty much outlaw abortion altogether, even in cases of rape and incest. So there isn't one law. There are many, many different laws now on abortion in different states. And so it all depends where you are. And that's part of the further criticism of what is happening in the United States, which is that particularly among poor women and as it turns out, very often Black women who are among the more deprived parts of the population, if they find themselves in a state where there is no abortion that is possible, they can't easily travel, they can't procure abortions, and so you get these very unequal outcomes where if you're poor and you're in a state that effectively has abolished abortion, you will have to have the child, and that gives rise to many, many social consequences that can be very adverse for the person concerned and their families, and for poverty and the like. There are many, many implications, including the heightened risk of mothers dying during childbirth, which is not in America has relatively high rates of maternal fatality. So there are many, many implications. And as I think the question is suggesting, some of those who are most fervently in favor of restricting abortion rights are in states where you don't find generous provision for child support. So people are keen. I mean, this is one of the contradictions that is often pointed out. People are very keen to have children come into the world, but not so keen to support them through welfare provisions once they're there. And that gives rise to child poverty, limited life chances, many, many social implications that need to be taken into account. This is not just a straight kind of ethical clash between views about the rights to life versus the women's rights to bodily integrity.
Agreed. And you mentioned like the consequence, like saying it's a potential tax revenue, some of the arguments put forward, but like on the flip side, with the children, as this Tindy has put here, there is that the children are unwanted, and the state does not support, and neither does the child's father. The child's father does not always support. And that's already even more taxing an already overtaxed child services and foster care system within the US already, which I don't think they really are acknowledging.
Yeah, indeed. I mean, one of the more bizarre things that Judge Barrett had to say, the most recent appointee to the US Supreme Court, is that, well, we should be less concerned about abortion rights because there are many ways now in which unwanted children can be fostered and made available for adoption. That seems like a fairly perverse argument, but others on this webinar may think otherwise.
Well, it's definitely an issue we do face in this country as well when it comes to our social system.
Of course.
So this next question, okay, this is an interesting one. It's asking, why must there be a restriction to the termination of pregnancy? And the argument is that ultimately all pregnancies will come to an end, depending on which points, whether maturely, prematurely, or even terminated, they would come to an end. So why must there be a restriction to the termination of pregnancy?
Well, it's true that all pregnancies come to an end, but there is a fundamental difference between a pregnancy coming to an end with the birth of a child and a pregnancy coming to an end by reason of the termination of the pregnancy, i.e. the elimination of the fetus. For those, I mean, I don't think anybody thinks morally that there's an equivalence between a pregnancy that ends with the birth of a child, a pregnancy that ends with the termination of a pregnancy when the fetus is viable, and the termination of a pregnancy when a woman is 3 weeks pregnant. I mean, those are just not morally equivalent. So I don't think, I mean, I know this question is being posed on the other side of the debate, which is that, all pregnancies come to an end. Therefore, why should we differentiate the means by which they come to an end? Why can't people just abort whenever they wish? It's just another way of bringing a pregnancy to an end. But it really isn't, because there are material differences. I mean, if that argument were to be taken to its logical conclusion, you wouldn't then differentiate between ending a pregnancy which caused a child who was 1 week from being born, from being effectively killed, with killing a child who has just been born. I mean, we would not readily allow either events to take place unless, for example, in the case of the very late stage pregnancy, there was a risk to the mother's life or to various handicaps and significant problems for a child that was about to be born. But, we do make these distinctions, and they do matter because they have important consequences for how we think about life and how we think about the viability of a fetus.
Agree. So it comes out to can be down to case by case basis at times, and the laws are just a framework of where to.
But I'm not, perhaps I haven't entirely understood the thrust of that last question, but I do think that there's no moral equivalence between every form of ending of a pregnancy. They are very, very different things that happen and with very different consequences that I think almost everyone would recognize.
Agreed. Okay, this next question I think would be best to end off on at the end of the question answer session. So we'll come back to it. I think this is just a comment relating to other questions we have done. Is it saying that several nurses have trained to do abortions, and that if doctors are unwilling to be involved, they should rather refer them to a center where an abortion can be done safely.
Yeah, that seems very sensible. That seems very sensible. I mean, I think ethically, I would imagine that both nurses and doctors have got obligations as a matter of their professional their professional ethics to ensure that patients who have a right to an abortion are placed in a position where that can take place, because that is their right. And so if a doctor feels that he or she can't give the abortion because of their own ethical positions, and I'm not sure whether, I don't know what the code of the health practitioners has to say about this problem, but certainly it would be that you would need to take steps actively to ensure that that patient was not in any way compromised in their rights to procure an abortion, if that's what they wish to do.
What reasoning is given by the Constitutional Court to say a fetus is not a person? So what reasoning have they given?
Well, the Constitutional Court hasn't decided that point yet, but there is a case that has been decided in another court that has said that, and I mean, essentially because until a fetus becomes a child and is born in the world, that fetus is a potential human being. It is not yet a person. I think that's fundamentally the reasoning. You don't equate a potential person with a person, because the bearer of the right must be a person, and the capacity to have personhood is coincident with the birth of the child, not with the fetus, which is not yet fully formed. I think that's the reason.
Thank you. Let's go another comments here about, with regards to when it comes to the abortions, that if it's a 20-week abortion, that has to be done by a specialist or good specialist on, I would say, solid medical grounds. So there will have to be medical reasons for the abortion there. And if it's 12 weeks or less, it's regarded as less dangerous. So I think that would come down more to what the mother would like.
Well, the 12-week period, the mother's got a right to, or the woman has got a right to an abortion. In that 13 to 20 week, it's a question of would the pregnancy going to term affect the physical or mental well-being of the mother, which is of the woman, which is still a fairly permissive test. And it's only after 20 weeks that, of course, it becomes very, very restrictive. And there you're concerned with, is there a risk to the life of the mother, or that there might be such disabilities that attach to the child that would be a reason to terminate a late stage pregnancy. But I think it's not just about the safety of the procedure, though that's one of the considerations. I think it also reflects this balance I was talking about between the recognition of the rights over reproductive autonomy, which are significant rights at the early stages of a pregnancy, but can be more readily limited by legislation at later stages where the interests of the potential child start to figure, and the state may take restrictive measures to try and limit the woman's rights.
Thank you. So we are past 9 o'clock. I think there's about 3 different questions. Like I know there's more in the Q&A, but a lot of them are relating. And so I want to start with this one question. Like this is going to be, I think, is a very interesting one. Does the woman's right to reproductive freedom always overrule the rights of the father? And just to follow up on that, have there any cases about that where the man will want to have a kid, but the female does not want to get pregnant? Is there any case where the father has said, "I want to have the kid," or does the mother's right to her freedom overrule his right?
I'm not aware of a case that has been decided on this point, but I would imagine that it would be very hard for a father to contend, one, that he has a right to insist that his partner, wife, or the woman with whom he has had sex, that his rights trump hers. Because the Constitution gives an express right to a woman over her bodily integrity and to her reproductive autonomy. And I'm not clear what right the father could assert to have the child. So I think I can't see very clearly how a father could have a right to insist that a woman must go to term and give birth to a child. And if the father had such a right, I can't see how it trumps the woman's right to reproductive autonomy.
And neither could I, because no matter what that ruling would say, it would still be the woman who would be carrying it, taking the stress on her body. And as men, we can't begin to imagine what exactly that stress would actually be. So we don't really have a dog in this particular fight in that regard, because we do not know the exact stresses ourselves.
Yeah.
Our second to last question. Let me see for quick. Just try and find it. Okay, here we are. Prior to the Roe versus Wade case, many women died from backstreet abortions. Did the number of women dying from backstreet abortions, did those decrease after abortions became legal? And in addition, did the number of abortions increase significantly once it became legal? Finally, what was the whole point of removing the law when there was no medical evidence that would improve the lives of women and fetuses? Okay,
I'm not sure about the last part of that question, but let me at least respond to the first 2 parts. The statistics tend to indicate, as far as I'm aware, that in the United States, 1 in 4 women has had an abortion at some point in their lives, which is very, very high. The number of illegal abortions definitely decreased once Roe versus Wade came into law. They didn't come to an end because in many states there were still and remained all sorts of efforts to try and limit the number of abortion clinics and try and prevent abortions from taking place by other means of restricting access in one form or another. But the number of illegal abortions certainly decreased significantly, as you would expect. Whether this is now going to change, I think, is an open question. One would imagine that there will be more, sadly, more recourse to illegal abortions. Although one aspect which is relevant is that at least in the early stages of pregnancy, there are now pills that can be procured over the internet to terminate the pregnancy with relative safety. And I think that's going to become more and more the prominent mechanism for abortions in states that have ruled abortions to be unlawful.
Yeah. As for that final part, I think I understand it now. They're asking, what was the whole point in removing the law when there's no medical evidence that removing this type of abortion or making abortions illegal improves the life of women and the fetus? So he's asking, what is the point of that? There's no medical reasoning behind it.
Well, I mean, the reason, I think there is medical evidence that making abortions legal has a huge impact on on women's health, because recourse to illegal abortions, gives rise to all kinds of risks. But in addition, recourse to lawful abortion as an option for women in their reproductive choices means that fewer women go to term in pregnancies, which themselves have, particularly among poorer women, much higher levels of maternal fatality. So I think there is quite a lot of evidence that that a regime of lawful abortions actually is greatly advantageous to women's health.
Thank you. So, okay, we have a couple more. So, final two questions, I promise. So, just a comment, 28 weeks plus, the birth of a non-viable child is defined legally as a stillbirth. Less than 28 weeks, it is a miscarriage. Is this relevant when a fetus is viable or is a legal person?
I don't think so, because the question of personhood really depends upon birth. These definitions as to when there's a stillbirth or a miscarriage, I don't believe really has an implication for the question of when is a child a person, or at what point does personhood begin, to put it more accurately. And the fact that a fetus may die at different points, not as a result of intervention by way of an abortion, but for other reasons, seems to be a set of distinctions that don't really make a difference to the debate about whether an abortion, whether a fetus is a person. It would mean, if you did take a fetus to be a person, that in every instance of either stillbirth or miscarriage, a person had died. But I'm not sure that there's an implication in that goes much beyond the semantics.
Thank you. And now on to our last question. I think this is probably the best question to end off the Q&A session. Can the ruling that has overturned Roe versus Wade itself be overturned? If so, how could this be achieved?
Well, that is a very interesting question indeed to end off on. I mean, the formal answer is, just as Roe v. Wade was a precedent that could be overturned, a differently constituted court, if it came to the view that the Dobbs decision was incorrectly decided and that a different basis existed, which perhaps hadn't been fully or properly considered, that yielded an answer that there was a right, a constitutional right to abortion, then they would overturn Dobbs. But there are a few things to be said about that. The one is that it is dangerous for the rule of law to have courts that keep changing their minds. Stability of law matters a great deal so that people know where they stand. The second thing is that one of the concerns in the US is that, at least on these kinds of issues, the US Supreme Court has become deeply politicized and factionalized, and that is not good for the legitimacy of a court. If people think that they're not, they're just taking partisan decisions. And so one would have to weigh very carefully whether a further revision would be desirable for systemic reasons. But I think if the court, and this is not going to happen anytime soon, because that court is set to have a conservative majority for probably decades to come. But if the court were to be differently constituted at some future point in time, indeed, Dobbs could be overturned, but there will be many reasons why the kind of caution about overturning long-standing precedents of significant importance to the constitutional structure of a country are not decisions that should lightly be overturned.
Thank you very much. And I think that we'll call that time for tonight. Thank you again so much, David, for agreeing to this talk. It was truly insightful. I could see that from the comments and from the Q&As, even those which are left over. It really has ignited the debate again. And hopefully we'll be able to move forward with a more concise understanding position globally, especially considering Roe v. Wade is used as definitive abortion rights globally, not just in the US. Thank you. Thank you again, Judge David Unterhalter. And thank you to everybody else for joining us tonight. I hope you enjoyed tonight's talk. And I'm looking forward to seeing everybody again next week. Night, everybody. I will be on for a little bit. If there's any technical queries or questions about MedTalks, just please put them in the chat and I will answer them as soon as I see them. Thank you. I just saw a question from anonymous attendee. Wasn't comfortable saying during the Q&A, but says earlier you mentioned how roughly 70% of the US population is in favor of the woman's right to choose. How can this be given that the majority of the US population professes to be Christian and therefore pro-life? A counter argument to that would be that in the wake of the overturning of Roe versus Wade, Mexico and Ireland have progressed with abortion rights, and those are very heavy Catholic countries. So hopefully that might give you an answer there. As well as when it comes to political leanings and ideologies in the US, it's much harder to identify because a lot of it's based off polling, and unfortunately they use the college system, the electoral college system, which has skewed where the actual measurements of Republican, Democrat, and third party are within the state. I think every constitution outlines how many constitutional court, Supreme Court justices, whatever the term used in the country, can be on the bench at a time. I think that's how it works. I'm not entirely sure. Please let me know if you have any other questions or anything. Just put them in the Q&A and I will get back and I will respond. Otherwise, I will be shutting down the webinar at 9:25. If you don't have any questions, you're more than welcome to leave the webinar now. You can just hit the big red leave button. I'll be shutting down the webinar in 4 minutes. Can I please ask if you can just leave in the next 2 minutes? Thank you. Hi, baby. Sorry, I just saw that now. No, it won't affect it. We see on our logs if you get kicked off when you come back on and we keep track of the minutes. But if that's happened, it won't affect your CPD points. You're very welcome. And we will try and look at other legal webinars, like if there's any legal things you may be wondering, we can maybe set up some series and we can also discuss how you may want it to be shown. Like, do you want just be for doctors, or do you want the general populace also to be aware of certain things as well? I'll be shutting down the webinar in 2 minutes. And thank you so much for the nice comments, everybody. This is my first time organizing a webinar. I was a bit nervous, but thank you for the kind words.